broad term.
But Congress also said what it was doing in the report. This is the thing that is a little troublesome for me, that to the extent that you are relying on arguments about what Congress actually intended, as opposed to just looking at the words of the statute, it seems to me we're in the territory where we look at the House report and see what Congress said about what it was doing. And in the House report, Congress described the existing causal nexus requirement, saying that federal officers, quote, must demonstrate a causal connection between the charged conduct and the asserted official authority. And in the testimony Congress looked at during that time, consistently people said we're not trying to change that standard. So if we are interested in being consistent with what Congress intended, I don't understand why the evidence doesn't show that Congress was not trying to change this standard.
So we see a difference between identifying statutory objectives by looking to this court's 150 years of case law, applying this statute, and looking in the specific House report.
No, but you said Congress is coming in eyes wide open relative to our case law. And what I'm saying is yes, and then they wrote what it is that they were trying to do in the report.
And to be clear, we absolutely agree that the motivating event for this act was that a congresswoman found herself stuck in state court in a subpoena case, and Congress didn't like that result and wanted to make sure that the congresswoman could have her case in federal court. But I don't think it follows that that specific problem that motivated the act is the breadth, is the sum total of what Congress did. And I'll, I think, offer the same answer as Mr. Clement, which is we know that from the text. And of course, we also know that page 6 of the House report, the section by section analysis.
Do you think they lose if I disagree with you?
So
I mean, do they not meet the causal nexus test here?
We would say that the relating to theory does not meet the pre-2011 test, but it does meet causation in a sort of broader sense.
No, I mean on these facts. Does Chevron lose if we disagree with you about the causal nexus requirement?
No, for two reasons. First, we of course have our alternative argument that the Petroleum Administration for War was supervising all of this directly, causally, et cetera. We also think that there is causation here, if you want to call it that, in a sort of looser, broader sense of the word, that relating to would clearly encompass along the lines of Justice Alito's concurrence in Ford Motor Company exploring this question in the personal jurisdiction context. Because we know that the reason that these companies were refining their own crude oil was not a matter of happenstance. It was because the federal government specifically told them to do that because, in part, this crude was uniquely suited for making avgas. And we also have causation here at a broader scale in that there's no question that these oil companies generally increase production to meet their needs, and so the only difference here comes from the happenstance of respondents having tried to slice this case up.
Thank you, counsel. Justice Thomas.